So how much does it cost to enforce a trademark? Obviously, people are generally afraid to get involved in any kind of litigation because you can look up all kinds of horror stories about how much it costs and all that. And so I wanted to do this video to encourage you, to give you some information about how to keep those costs, how to set up your case so the costs are as low as possible. There are things that you can do that help. And also just give you some ballpark numbers of what to expect in terms of like timeline and money over time. That way, maybe, hopefully, you will not be as afraid. This hopefully will be a good news video because if you're expecting $150,000 to enforce your trademark, I'm here to tell you that the vast majority of trademark conflicts are resolved for way less than that. So there's a couple things. There's really two factors that are the top factors that affect the cost. The first one by far is the strength of the case. The stronger your case, the less you're going to have to spend to enforce it. Partly because the lawyer on the other side, if they're a trademark lawyer that understands trademark law and you have a very strong case, they're going to know you have a strong case, and they're much more likely to go to their client and say, look, you have a weak case, you're going to lose, let's resolve this. So having a very strong case is the best thing you can do to reduce the cost of enforcing your trademark. That might sound really stupid, like, of course I want to have a strong case. But let me tell you how you can make sure that you have a stronger case is to clear and register your trademarks early. Do not procrastinate that, because if you procrastinate, the best time to do it is before you actually start using the trademark in commerce. That way, if there's issues, you can choose a different mark and not set yourself up for a big expensive enforcement fight 5-10 years down the line. Do not wait. Do it proactively, do it early, and you will save hundreds of thousands of dollars over the life of the trademark in enforcement. Okay, so there's my little soapbox. It really does make a difference. So when you have a strong case, so I'm talking registered trademark with early priority, and you've got actual confusion, this is actually something that's hurting you. Not that I wish that for you, but those are the strongest cases. Or maybe it's something where it's going to be a problem because you're playing in the same sandbox and you've got to shut these people down. Maybe they're online on Amazon or on social media and they're stealing your traffic. All of those things can be strong cases. So if your trademark is registered and you have early priority before they appeared on the scene, you have a strong case, and that's going to be a lot less costly to enforce. All right, the other thing is related to the strength of the case, and that is how long you have to fight them before you resolve the case. The longer it goes on, the more it costs. So, the stronger the case, presumably, hopefully, if your lawyer is working aligned with your goals, the faster you're going to reach resolution on that case. There are some other factors. I'm not going to get into them in the interest of time. Those are the two big ones. So how much are you looking at? So the first thing is to look at the strategy of what is it that you actually want to do to take action. If you can resolve the case at the letter stage, which many cases in trademark enforcement cases are resolved when it's just letters back and forth, in that case you expect about somewhere between 5,000-7,000, under 10,000 to resolve it at the letter stage. It could go longer than that if you're just sending letter after letter after letter. That's kind of wasteful, and so I don't generally like to do that. And if the second letter doesn't do it, then it's time to rethink the strategy. Again, strength of the case. So letters back and forth, you're looking at, I would say, well under 10,000 to resolve that case. If you then have to go kind of the next level, I would expect, so it's out, if you go all the way to trial with trademark infringement in federal court, yes, it could be $150,000. The vast majority of cases don't have to go all that way and don't even require necessarily federal litigation in federal court to get resolved. So There are all kinds of different things that we can do. There's things at the USPTO in some cases that we can do that it's a more limited case. It's also a bit faster. But it's a more limited case. There's less to fight about. You can't get money for it. It's just about, it's really about stopping them from registering a mark. But it can be used as leverage when you have an infringer. So that can also reduce the cost that TTAB cases expect if it went all the way, which it probably wouldn't in an infringement situation, but if it did, it would resolve early is what I'm saying. If it did go all the way, you could expect maybe 30,000, 40,000. It seems to be what they come in for us. Most of them actually seem to be resolved around 11 or under. You might even have a situation where they don't answer it. Again, that's more about registration, but it can be used as leverage. And it's cheaper than regular federal litigation. Regular federal litigation, I would say expect 10 or 15 to, maybe 10 to get the complaint filed, anywhere from 7 to 10, and then plan maybe, at that point, we've maybe 5,000 the next month. It depends on how, whether they're fighting back and all that. But what I wanted to say about that is we have found in many cases, if the letters aren't getting anywhere and we file a federal lawsuit, it gets the attention of the other side. Now they know you're serious. And that's the point where they're willing to come to the table. So this is, again, why the vast majority of cases, even federal litigation, they don't get anywhere close to $150,000 because it is expensive for them also. And so it has a tendency to bring people to the table if they're not being responsive. All right, so again, we've had lots of cases where we file a nice, strong complaint, and then immediately we get, the other side is more willing to talk, and we are able to work out a settlement. I even had one where principal to principal, the two companies worked it out within a week after we served them with the lawsuit. And so that one was very efficient for that client, and it involved an Amazon takedown, which they were able to get resolved. So again, I hope this is helpful. I know it's a little long, but I really am hoping that your takeaway for this is that if you have a strong case and you act proactively, don't delay going after them and don't delay getting your trademarks cleared and registered, that you are looking at a fairly modest investment to enforce your trademarks compared with the lifetime value of that trademark or the revenue that you're losing from having an infringer out there, not to mention the reputation that you're losing if they're doing bad stuff with a similar name. So I hope that was helpful. Catherine Cavella, IP Works Law.